Subdivision C. Here's a fair question for them to ask. Don't know if they will, but it's a fair one. Papers filed to commence action or special proceeding. For the purpose of CPLR 304 governing the method of commencing an action, the term clerk of the court shall mean the county clerk. Make sure you know that. When we're talking about Supreme and County Court, the fucking clerk is the county clerk. Okay? It's not a clerk's office. Okay? It's the county clerk. That's where you pay. That's where you file shit. Each county clerk and Supreme Court chief clerk shall post prominently in public areas, notifying people you got to go to the county clerk to commence an action. Oh, and the postage notice got to specify if you're designating someone else to accept filing. Subdivision D is where the question should come from. I know I told you guys this already, and I hope you're fucking listening. And maybe you already have this list memorized, so I'll kind of go fast. But this is where I think the question should come from. It's totally fair. When does the county clerk or chief clerk of Supreme Court refuse? When are we authorized to take that paper, look at it, and hand it back to the attorney and say, fix this, go away? When it's provided by fucking chief administrator or statutory to reject something you rejected. Other than that, we have a list. 1, no index number. 2, the summons, complaint, petition, or judgment is lacking a full caption. So it says et al. No good. But again, that is only summons, complaint, petition, or judgment. An answer can say et al. 3, paper filed in the wrong court. 4, paper is not signed in accordance with Part 130 of the rules of the fucking chief administrator, which basically says you have to sign, a lawyer must sign a paper to certify that the paper is not frivolous and that he's examined it and shit like that. 5, the action is an e-filing action and the document is not being e-filed, and it's not being filed by a pro se person who is exempt from e-filing, or in a consensual e-filing program there have to be a notice. So if it's missing the notice or it's not electronically filed and it's not a pro se person or somebody who's exempt from e-filing, then you can reject it for that. And that is it. That is it. Those are the only times that you can reject a paper. A county clerk or chief clerk must signify their refusal by use of a stamp that says the date of refusal and the reason. So you can't just hand it back to them and be like, fuck you, I'm not taking this. You have to say why. Also, it also says that the county clerk shall require payment of the proper fee before accepting a paper for filing, which makes sense because they gotta get their money. Here's another one of my preferred, what I think they could ask. And this is about CPI, which is confidential personal information. So basically, confidential personal information is like the stuff that can cause you to be a victim of identity theft, like a bank account number, a social security number. And it's all the numbers in that number except the last 4 digits. Now, there's times when it's automatically, whether or not a sealing order has been sought, they have to redact CPI. And the exceptions to this are, so this is when you don't redact CPI. In a matrimonial action, proceeding in a surrogate's court, or Article 81 proceeding, which is a guardianship proceeding under the mental hygiene law. So again, when do I not automatically redact CPI? Matrimonial, guardianship, surrogate's court. This has a lot of information in detail that it goes into. I'm going to skip this. If you guys have time, I will make another video where I really go into depth in this rule. But for now, I'm just going to say just read it. I don't think they're going to go there with any question except what I just said. Knowing what is CPI, it's basically like a tax identification number, your date of birth, except the year, stuff that can make you a victim of identity theft. And if it's a minor, you can only use their initials. So minor, only initials. But again, I don't think they're going to go crazy with that. I think if they're going to go there with the question, it's going to be the easier version, which is, when do I not redact it? Not about this in-camera review and everything. So basically, if I get sued because, Sears is saying I didn't pay my credit card from like I don't know, like 10 years ago. I'm like, I never fucking had an account with Sears. Me appearing and saying that as my defense, now they have two options. Sears lawyers, they can either, or whatever debt buyer bought this debt from Sears, they can either file the document with the full CPI under seal, or they can file it for an in-camera review. 202.6, request for judicial intervention. So this is an RJI. This is what takes the case from being a case floating around in limbo and actually gets it assigned to a judge. Now, there is a fee for an RJI. It is $95. You don't have to know that, but just know there is a fee for it. And that at any time after service of process, so you do not have to wait for defendant to answer. It's at any time after service of process, any party may file an RJI, except as provided in sub B, which is the exceptions. In an action not yet assigned to a judge, the court shall not accept for filing, and then we have a list of 8 items that may not be filed unless it is accompanied by an RJI and the appropriate fee. And what is this list of 8? Well, we have 1, notice of motion, 2, order to show cause, 3, application for ex parte order, 4, notice of petition, 5, note of issue, 6, notice of med mal, dental or podiatric malpractice action, 7, statement of net worth, 8, request for preliminary conference unless it is accompanied by an RJI. So you have to memorize this list of 8, and then no matter what they throw in there, you know, oh, wait a minute, I don't need an RJI for that. So basically, if I'm defendant, I'm filing an answer or a notice of appearance, I don't have to file an RJI. I just file my answer and notice of appearance and let the fucking plaintiff pay for an RJI. So again, to review this list of 8, notice of motion, OSC, which is an order to show cause, application for ex parte order, notice of petition, note of issue, notice of med mal, request for PC, statement of net worth. All those, you have to have an RJI, which must be submitted in duplicate on a form authorized by the fucking chief administrator with proof of service on all other parties, and that is not required when the action is ex parte. So if you're filing some kind of application where there's no proof of service required, you don't have to do that. B, when is there an exception? So the exceptions talk about when do you file the RJI, but you don't have to pay the fee. So the trick question is, when do you not have to file an RJI? The answer is you always have to file an RJI, but you can be exempt from the fee. So this list of 11, I kind of have it already beaten to death in another video, but real quick. An application not filed in an action or proceeding. 2, petition for sale or finance of religious or nonprofit property. 3, name change. 4, habeas corpus proceeding where movement institutionalized. 5, application for court assistance in obtaining disclosure in an action pending in another state. 6, retention proceeding, Article 9, mental hygiene law. 7, any proceeding authorized by Article 10 of the mental hygiene law. 8, appeal to a county court from a court of limited jurisdiction. 9, application of vacate judgment on account of bankruptcy. 10, motion for order authorizing emergency surgery, and within the city of New York only, an application for an uncontested divorce, annulment, or separation. Commenced pursuant to 9, 10, or 11 of the DRL, Domestic Relations Law. And the filing causes the action to be assigned to an assignment judge. So basically, I'm not going to beat that list to death. Go watch that other video. I promise you will not forget it. I fucking harp on that list because it's so important. This video is way longer than I anticipated, so I'm going to stop now. This covered only rules through 202.6. And then there's a lot of time rules in 202.6, and hopefully you've been reading it already so you know them. Just keep going over it. You'll remember this stuff eventually. It'll stick. 45 days preliminary conference. Oh, I know that. 60 days for motion to be decided. So a report of undecided motions makes sense that they would want to know what motions are undecided after 60 days. No more than 3 stipulated adjournments for an aggregate period of 60 days. And the motion time rules, 16, 7, 1, 8, 2, and 0. And for a standard case, 12 months to complete discovery. So basically, if you file a motion for discovery and there hasn't been a preliminary conference held, or you file a request for preliminary conference and it's basically a discovery motion, you want discovery, the court will send you a form. And if everyone fills it out and agrees to timetable for discovery and everything, then they all sign the form, the court so orders it, and the conference is canceled because you all agreed something. One more time rule they stuck in here. When is the case assigned to a judge? After the RJI is filed, when is the case assigned to a judge? And the answer is, as soon as practicable, the case is assigned to a judge. As soon as practicable. So, after the RJI is filed, as soon as practicable, the case is assigned to a judge. So again, the 5 days is talking about, so if I serve a motion on the other parties, but I don't even have like an RJI filed, I served my motion, I gotta go to court within 5 days after I served it on the other parties, pay for my motion, pay for my RJI, get the case assigned to a judge. Now, 60 days, that rule is talking about undecided motions. So there's a report of motions that are undecided past 60 days. So the same rule, their judge is supposed to decide the motion within 60 days unless it's a provisional remedy, which is 20 days. That's why the report is talking about 60 days.